Hello, everyone, and thank you for joining the Nonprofit Learning Lab for today's workshop. If you have any questions along the way for our presenter, you can type them into the questions box in your GoToWebinar control panel, likely on the right-hand side of your screen. If you have any tech questions, you can also type them there. If you are interested in receiving the recordings and materials from today's free webinar, you can visit our free webinars page on the Nonprofit Learning Lab website, or you can send us an email at program@nonprofitlearninglab.org. And without further ado, I will now hand it over to you, Amy.
Thanks very much. Morning, everyone. I'm very pleased to be here today. Thank you all very much for attending the seminar. And thank you very much to the Nonprofit Learning Lab for having me. So a little bit about me before we get started. I'm attorney serving nonprofits, small businesses, and creative professionals, especially writers. So I do work with a lot of intellectual property. I have served as an executive director of a nonprofit as well, the Farmer Chef Alliance, and I've been on the boards of numerous nonprofits. So I'm kind of coming at this from various different angles, so different experiences with nonprofits. And last year I completed a fellowship with Chicago Lawyers Committee for Civil Rights, where I work specifically with area nonprofits in the Chicago area. Probably worked with over 60 different nonprofits during that experience. And I'm a member of the Justice Entrepreneur Project, where we pledge to, for the most part, serve middle income clientele. So today, some of the things we're going to be talking about is identifying your protectable intellectual property. Sometimes people aren't quite sure, what is protected and what forms of protection. Kind of tossing around the ideas of copyright and trademark and which one protects what, and the types of things that you might have that would be protectable. Your blogs and newsletters, certain types of fundraising campaigns, if they're kind of unique to you and you've created them. Certainly annual reports, your photos, social media posts are even protected to a certain extent. We'll discuss that. And then a big one, of course, here is how to safely use other people's works. So we'll understand what public domain is, which is different than publicly available. That's always kind of a sticking point with a lot of people too. What fair use is, and then if those don't apply, getting permission to use other people's work. And then we'll finish up with a few bullet points of what to include in agreements with independent contractors and even volunteers. So let's start with copyright. Copyright will protect your written work, your photos, those kind of things, artwork. So what it is an original work of authorship set in a tangible medium of expression. So what does that mean? So that means, an original work, does it have to be something completely novel that's never been seen before? No, but it does need to have some sort of modicum of originality. And then set in a tangible medium of expression, that means just as soon as you've written something down or saved it to your hard drive, that is protected by copyright. So don't worry about, oh, I forgot to copyright this, or, I forgot to put that circle C next to, my photo, or don't worry about that. It is protected by copyright. We'll talk about registering it. So that's an extra layer of protection, but it isn't necessary to protect your work. And then also conversely, though, don't also think that, hey, you found something online, this great poem, this photo, hey, it doesn't have the circle C symbol, it must not be copyrighted, I can just use it. So that's also not true. So somebody else does own that, even if you don't see that circle C. So it is still a good idea to use that circle C, and what you would do is say, copyright or circle C, and the year it came into being or was published, so 2022, and the person who owns the copyright, Amy Cook, or the name of your organization. We'll talk about that too, who actually owns it. So who owns the copyright is usually the person who created that work. Like, say I do write an essay for your nonprofit. The person who created it usually does own it. But if it's the employee in the scope of their employment, then the nonprofit would own it. But keep in mind that it would have to be, that's always a sticking point in legal cases of it's in the scope of their employment. So for instance, if one of your employees does something else as his or her main job, and it has nothing to do with, but they're then also a photographer in their spare time, and they're like, hey, I took this great photo, do you want to use it online? That's not within the scope of their employment necessarily. So kind of be careful about that. That might be something where they'd be happy to sign over the rights to you, license it for you to use it in a certain way. But if that's not something they normally do, you didn't hire them to be a photographer, then be careful about that. So then I also have a note here that do keep in mind that if somebody is taking photos or writing articles for your blogs and newsletters, it is owned by them unless you have a separate agreement with them. So like, for instance, your volunteers. So that's why it's a good idea just to have a nice, simple agreement with your volunteers. They love your organization. So I'm sure they'd be, happy to help you out, but legally it is owned by them. So a copyright lasts the life of the author plus 70 years. So if it's owned by a corporation, and that means a nonprofit as well, it will last 95 years from publication or 120 years from creation, whichever is shorter. Now, work for hire, like a lot of people probably have heard that term, a work for hire. So people just kind of toss around that phrase of, oh, well, I just, hired so-and-so to do this, right, to design our website or to take these photos or to write this for us. And I hired them, so it is a work for hire. But that's just not how work for hire really works. It really is kind of a legal term of art. So a work for hire, again, is an employee within the scope of their employment or something that's specially commissioned. And it has to be in writing for something to fall into a work for hire. And it has to fall into one of 9 categories. And they're a little weird, so I just put a few of them here, some ones that might possibly be relevant for nonprofits. If it's a contribution to a collected work, an instructional text, a translation, a compilation, so there's 9 categories that it must be one of those things in order for it to be, if it's specially commissioned, it must fall into one of those 9 categories. Just be aware of that. So if you decide you do want to register copyright, it really is not too burdensome. Trademark is definitely a little more burdensome. So copyright's something you can do yourself or have your lawyer do it. It's not too difficult. As I said before, you don't need to register your copyright to be protected, but registering does provide additional benefits in the event of copyright infringement. So you would be able to get what they call statutory damages and not just actual damages, which of course can be the difference of thousands or tens of thousands of dollars. So again, you would need to have registered the work before you'd be able to file a copyright infringement lawsuit. And another side note on that, you may be thinking like, oh gosh, I don't know if I want to even register, let alone I can't imagine filing a copyright infringement lawsuit. And you're right, they can be extremely expensive, but they just started a brand new thing, literally just started in June. It's a kind of like essentially a small claims court for copyright infringement. So you don't need to have lawyers involved. It's for much smaller dollar amounts. So just kind of keep that in mind as well if that ever comes up for you. So you go to copyright.gov to register and you file online for most things. And here's just some sample fees so you get an idea of what you're looking at if you decide to do this. Most things are $45 for a single author. It kind of goes up from there. And they do have another fairly new thing. This came out a year or 2 ago, I think. It's a form GRTX, so that is specifically for short online literary works. So it's between 50 and 17,000 words and first published as part of a website or online platform, including online newspapers and social media sites and social networking platforms. And some of the things that would be available to register with that are just kind of the things that we're talking about here today: poems and short stories, articles, essays, columns, blog entries, social media posts. And so what's great about that is that you can combine a lot of those together if you so choose to register those. So what happens if someone infringes your copyright? First to do is determine if it was a fair use, if their use was a fair use. And we'll talk about fair use in just a moment. So make a copy and kind of note when and where you saw the infringement. For instance, if you do have some really great website and you post a lot of great material on it and photos and writings and maybe even instructional materials, and somebody just lift those and puts them on their website and starts using those, you definitely want to tell them that they need to stop that it's copyrighted by you. So find out who it is. If it's a website, there should be some sort of an email address or a physical address. Check their terms of service and privacy agreements. Sometimes ways to contact a website is found on those documents. You can look at that whois.net or go to some of those domain registry, such as the GoDaddy. Excuse me. So if your work appears on some other sites, so like those big social media sites, you can contact them and tell them that your copyrighted work is appearing there and ask them to take it down. And so when you do contact them, the infringer, you would ask for proper credit, meaning that your organization owns the work. You can ask for money, like, hey, I'll license you this work. That's always nice, instead of just kind of telling them to take it down. Depending on the circumstances, you might want to ask them to take it down, which would be like a cease and desist. But, depending on what it is, you might just want to kind of license it to them and say like, hey, you can use this, but, you have to give us credit and you also need to pay us for it. Move into trademarks. Trademarks are things that just identify your goods and services in the marketplace. They can be so many different things: words, symbols, short phrases, designs, logos, and I even have found out in the last couple of years, even colors and scents can be trademarked. So that's interesting. Like think the Tiffany blue box, that's trademark of Tiffany. So definitely think that this is not just for like the big corporations. I'll come back to this slide, but these are kind of the examples of like you see these trademarks of nonprofits, and you immediately recognize who they are, what they represent. Even if you didn't see the wording with it, you would just be able to look at like the logo, the colors, and know exactly kind of product or service they're offering. So it's also meant to prevent consumer confusion in the marketplace and to protect your goodwill that you've developed in the marketplace as well. So if you haven't federally registered your trademark, you can use that TM, or if you just state registered it, if you're really just working within your state and you don't feel the need to federally register your trademark, you can state register, which is much cheaper, or you don't even need to register. Once you've kind of built up that you've been working in a certain area geographically, you can use that TM. But the Circle R is only if you've been federally registered your trademark. It's a little bit more complicated to register trademarks, so if you want to do it yourself, make sure you do a lot of research and reading beforehand and get yourself familiar, or this is also a good one to contact your attorney for. So you go to USPTO, which is the US Patent and Trademark Organization, and some sample fees here are $250 for most things, but keep in mind that is per class of goods or services. So for instance, you might have a bunch of different trademarks, with your nonprofit. So the nonprofit name itself, you might have different kind of programs that, have really developed. With the organization I worked with, we had Chef Camp and we had Bread Camp, and eventually we did trademark those. Say your organization has a program teaching kids to cook, and you've got like, Tasty Bites, and so that might be your program name, but then you may have like really cute t-shirts that you put the Tasty Bites on, and tote bags. So those would be different classes, and those would each incur a different fee. So even if it might be the same words, it would be like, hey, this is the trademark for our t-shirts, this is the trademark for our tote bags, this is the trademark for a program that teaches kids to cook. So keep that in mind as well. So let's talk about using other people's works, because I know this is always a huge area of questions I get from a lot of people. And of course, 99% of the time when people do misuse other people's works, it's very innocent. You didn't really know. People aren't really doing this maliciously, but the law doesn't really care about that, frankly. So, you're kind of deemed to know, and so if you're like, hey, I just lifted things from other people's websites or their social media posts, and I just really liked it. I didn't know it was copyrighted. It is up to people to know these things. So let's talk about public domain first. And as I said earlier, that public domain does not necessarily mean publicly available. People do mix that up. I see it all the time of people saying, oh, hey, I just saw this on the web. It's in the public domain, and they use that phrase. Public domain are things that are either never protected by copyright, such as works from the federal government, or things that have fallen out of copyright. So generally, right now, I'm going to say generally, works prior to 1926 are in the public domain. So we'll talk about fair use, because it can be a little complicated. So there isn't really any firm definition of fair use. It's something where if you've been sued, you can then claim it was fair use, and then a judge decides whether or not it was actually fair use. But there are essentially 4 factors that a court would look at to determine fair use. So I'll go, this could be like an entire, we'll go over some of these. So the purpose and character of the use, so it does definitely weigh in favor that you're a nonprofit. But I have had people come to me and say, like, oh, I was told by other people that since I'm a nonprofit, I can't be sued for copyright infringement, or like we can use anything we want because we're a non. They're usually found to be that's not a fair use. But if it's a very, yes.
Tech support here. You just
Yeah.
cut out a few seconds. If you want to backtrack.
The nature of the copyrighted work?
Yeah, I think if you could just start from there.
Okay. Yeah, so the more creative a work is, the less likely it will be a fair use. But if something is a very factual work, if you're looking at something that's a history of something that's nonfiction, if it's news reporting, that can be taken with much more ease. And then how much has been taken. So take the very smallest amount necessary for fair use. Don't take large chunks if you don't need to. Take only what you need to take. And then kind of the biggest factor is the effect on the market for the original. So if you took somebody else's copyrighted work and then, like whether it's an essay, and then you kind of destroyed the market for the original, meaning the person who actually owns it like can't sell their work anymore because you went and published it and people already got it from you. They don't need to buy it from the creator. That really kind of puts the nail in the coffin of like, that's not a fair use then. And then finally, another factor is if you've transformed something quite a bit, it could be considered a new work. So maybe you took like the kernel of an idea of something else, and then you kind of went a totally different direction with it. That could be a fair use as well. So if it's something that's not in the public domain and not a fair use, you would want to get permission to use it. So permission can be exclusive or non-exclusive. Exclusive would, of course, would be more money usually. So find the copyright holder. So that's great where that copyright notice comes into play. Or you can go to copyright.gov and they can, there's a database you can search, or if you really need to, there's a fee you can pay for them to try to find a copyright holder. For books or magazines, you can contact the publisher. Send them a letter, detail what you want to use, how it will be used, where it will appear, all these kind of things, and what kind of credit line they want. I advise to not bring up payment right away. You know, you are a nonprofit, just contact them and say, hey, we love this photo, can we use it? And then if they come back to you and say, yes, that'll be, you know, $50, then, you know, fine, you can decide if you want to pay that or not. But, you know, being that you're a nonprofit and you've asked permission, there's many times that somebody might just let you use something, but at least you have permission that way. Talk very quickly about trade secrets because these are important with nonprofits as well. I work with several nonprofits that have quite extensive training and educational materials, and the way that they've developed these things are very proprietary to them, and they spent a lot of time and money doing this, and then they have independent contractors who do teach these, you know, their methodology for what they train. So they do have a confidentiality agreement with their independent contractors, so that the independent contractors don't, you know, take all their materials and go, you know, teach them elsewhere. Make sure that if something is a trade secret, that it's something, only disclose it on a need-to-know basis, and then make sure you do have a confidentiality agreement. I'm using those interchangeably as well, the confidentiality and non-disclosure agreement. All right, for the next few minutes, we're going to move into when you are using real people on your websites and social media posts, etc. So the things to worry about here, I shouldn't say worry, just be aware of, you know, make sure you're aware of, defamation, invasion of privacy, and rights of publicity. So defamation and invasion of privacy, well, defamation we'll start with, is a false statement of fact that injures a person's reputation. So the person bringing the suit must prove it is false and that their reputation has been injured, and they have to show that. You know, for instance, that they lost their job because of something that you said, or, you know, they have a small business and nobody comes to them anymore, or they used to, you know, coach their kids' teams and, you know, nobody wants them as a coach anymore. If it's a public figure, they have to prove actual malice. So, for instance, how this may kind of play out in the nonprofit world is, you know, those nonprofits, say you're telling, you know, Sophie, and you do use a pseudonym, you know, her story of surviving abuse. But if the person is identifiable in other ways, and then the abuser is identifiable then as well, and, you know, that person comes forward and says that, you know, it's completely false, and, you know, you kind of, you know, injured my reputation because of this. Other people can identify me and they know it's me. So be careful about that. And then, you know, another example here, this is actually a real life, this really happened. It wasn't a nonprofit donor, but so say you post a photo of your donor, Martha, sitting next to a known criminal at a baseball game, that can be considered false light. So that was a real case where somebody had a photo taken of them and they were sitting next to what turned out to be a known, mob boss, and it kind of implied that the person in the photo was there at the game with that person, and, you know, kind of damaged their reputation that they were hanging out with this, you know, criminal person. So that can be false light for defamation and invasion of privacy as well. So just be careful about those kind of things. If you are using real people, make sure what you're saying is true, and then if it is something very sensitive, make sure that their identities are hidden or that you have permission to use their names or stories. So invasion of privacy is a little more common than defamation. So this is something that can be highly embarrassing and not of legitimate public interest. So those nonprofits that are working with really sensitive populations, just be especially careful, like we just talked about a moment ago. You know, children, drug and alcohol abuse, domestic abuse, health conditions. You know, don't disclose any kind of private information or photos without telling the person how it's going to be used, and, you know, or get their explicit consent as to how it's going to be used. And be really careful about changing names and other identifiable information. You know, just be careful you've really kind of covered your tracks of that they cannot be identified. Rights of publicity, using a well-known person's name, image, or likeness. So how this could possibly work with nonprofits is say you're having an event in a park and, kind of a famous person or public figure walks by and, you take photos and then you post those photos online. Don't imply any kind of endorsement of your organization if there is none, or make sure that you get their written permission to use photos and other implications of endorsement if you have well-known people attending your events and galas and that kind of thing. So getting permission. I'm going to talk briefly about working with an influencer. You may think like, oh, not really going to go that route, but do consider that they can reach audiences that you are unable to reach, and it can open doors and raise awareness of your cause. They usually have so many followers that might bring attention to your organization. So just a couple of things to keep in mind if you do decide to do this. FTC does have some guidelines, and keep in mind these are guidelines, not laws. To have transparency and let your audience know that they have a relationship with you if you have paid them or requested endorsement, and that can be done just by those kind of hashtag type things. It doesn't have to be those words that I put right there, but things along those lines, just to let people know. Make sure that the person you're working with is truthful as to where funds are going and what projects you're working on, and the typicality. So talking about results, whether they're typical or not typical. If you've had amazing results with something, is that a typical result or not? Do make sure that you're monitoring what they are saying and doing when they're working on your behalf. And be sure that you're not crossing over into the influencer becoming a professional fundraiser, or if that does tend to occur, make sure you're doing the proper state registrations for a professional fundraiser. A lot of nonprofits do like to do contests or sweepstakes. I've worked with a few that do like a writing contest, or that have done a photography contest or artwork contest to maybe post online. Then maybe kids do some drawings, things like this. So sweepstakes are games of chance, and anyone can enter. Contests have some sort of skill or judgment, like I was talking about with a photo contest or short story contest. The different social media sites do have different policies about this, so check their terms of service. You should have no fee to enter, and make sure you describe eligibility and prizes. If you have a sponsor, identify them. Make sure you have an affidavit for the winner and releases that that you can use, like their name and photo, and if it is like an illustration or drawing. But make sure that you don't have a fee to enter, because then that means that it's a lottery, and those are highly regulated. All right, we're going to wrap up with just a few points here of these would be some various things that you might want to have agreements with. Website designers, events coordinators, fundraisers, photographers, videographers, writers, editors, these kind of people will be working on your websites and your social media. They're probably going to be independent contractors, could be volunteers. Spell out the scope of work in detail so everyone has an idea of what to expect. And especially if we're talking about intellectual property here, so make sure you really understand who owns what. Are they signing over all their rights to the work, or perhaps they're just licensing for a particular purpose? Say if it's a photograph, is it just for one use, or will you own that photo then? Just kind of make that clear in the agreement as well. We talked about confidentiality and non-disclosure agreements. Put that in your agreement as well, that they the things that you're showing them that you've spent a lot of time and money and effort creating, that they are your trade secrets, and that they won't use them themselves, they won't disclose to other third parties. A really important one is, especially if you're working with writers, photographers, that they're not going to infringe somebody else's copyright. There have been multiple cases of, website designers where they do take photos from other websites and then put them on your website. And just be sure you have something that says that, they've pledged that they will not infringe anyone else's intellectual property, and that if they do, that, they'll be responsible and not your organization. We talked about work for hire agreements. Make sure that they are in writing, and then actually use the words work for hire in the agreement. I'm sure many people on the call are understanding of this, but be sure that you're clear if a person is an employee or an independent contractor. And IRS has a whole list of things to know kind of the difference, because definitely can kind of get in some IRS trouble if you call somebody an independent contractor, but they're really working as an employee. With the employees, make sure that it does spell out that anything that they create during the course of employment belongs to the employer. That was kind of where we started at the beginning. You know, say somebody does photography on the side, you could put something in your employment agreement that you know, anything that create during work hours, you know, belongs to you, even if it's not something in the scope of their employment. So you can you know, tailor it to your needs like that. And then if you are going to be using other people's copyrighted materials, get permission if it's not fair use or public domain. Or you would use a release to use someone's photo, or if you've done an interview with someone, then get a release to be able to use those pieces of information. So just to kind of wrap up here, make sure that you are looking through what your intellectual property might be, and consider registering valuable copyrighted materials or trademarks, and make sure you're protecting your trade secrets. Use caution when using other people's intellectual property. Make sure it's in the public domain, or that you're just using the smallest amount, some of those other factors we talked about, or if you're not sure, just get permission. And then use simple but clear agreements with your independent contractors, employees, and volunteers. I'd like to just mention for a moment, I am a part of the Association of Consultants to Nonprofits. It's a really great organization, and they do have an RFP service and a consultant directory. So check them out if you're not already familiar with them. Really great organization. And then if we do have some questions, I'd be happy to chat for a couple moments.
Great, thank you. It looks like we have time for just one question. Megan is asking, how about social media memes, which often use photos of famous people?
Yeah, good question. Yeah, you're right. That does happen quite a bit. So with famous people, the interesting things with rights of publicity are there's a lot of times where people do things with famous people where they actually could sue, you know, an individual organization, but they really choose not to in most cases, because they just figure, hey, you know, I mean, this is going to happen a lot, you know, so you'd have to kind of go through those factors of like, are you kind of taking their photo, image, likeness for a commercial purpose, you know, to kind of raise money to promote an organization, like kind of without their permission? I would stay away from that. But if it's something in a very small use and you're not harming their reputation, and if it's something, you know, just kind of a parody, satire, silly, you know, well-known people are not going to come after you for that kind of thing. So, you know, again, there are things that like people see like in the tabloids, like, oh my gosh, like they'd said all these like terrible things about the celebrity. Yes, they could come after, you know, for defamation, but they, you know, in most cases, they just choose not to.
Great, thank you, Amy. This workshop has come to a close. If you are interested in receiving the recordings and materials from today's webinar, you can visit our free webinars page on the Nonprofit Learning Lab website, or you can send us an email at program@nonprofitlearninglab.org. Thank you so much for participating. And again, thank you, Amy, for educating our community.
Thank you so much for having me. I really enjoyed being here. Thank you.